Good morning and welcome, everyone. We'll just wait a few minutes to make sure everybody is able to log on and join our webinar. So just like 1 to 2 minutes, we'll get started. Okay, well, good morning, everybody. Hope everybody was able to easily log on and be part. We'll get started now with our quarterly sample policy update series. And this one's going to be a little bit different because we are also going to cover our special Title IX packet. And then as well as our more typical regular update packet, our September 2024 packet. Next slide, please. So we'll go over just very quickly our agenda for today. First, we'll have some housekeeping and presenter introductions. Then we will have a poll about the composition of who's attending our webinar. This really helps us to be able to focus our webinar appropriately. Then we will hear about some gamut updates, some policy updates, again, the Title IX special packet and our September 2024 packet. Then we'll have a second poll about if you, we're hoping you will evaluate us to make sure that we're doing our job well. And then at the very end, there'll be time for additional questions. We will also have time for questions in between each respective section of our policy update explanations. Okay, next slide, please. So just for a little housekeeping, just to make sure that to please use the Q&A feature to submit your questions. This is located on the ribbon below the speaker, and the chat feature has been turned off. And you can see from a little diagram exactly where to access the Q&A. And please know that your questions will either be answered in the Q&A feature in writing or live by our presenters, because like I said, we will have time for questions and answers during the presentation itself. And please know that all attendees, all of you will receive a link to the video of this webinar, as well as to the slide deck, which we hope you will find helpful. Next slide, please. So I'd like to start by presenting the presenters, which there's myself, I'm Barbara Laifman, and I direct the policy and manual development. There's Erin, who's our manager of technology, sales, and training. Dustin Bindreiff, who's our one of our senior policy manual writers, along with Meghan, who's another senior policy manual writer. We are joined by Maryela Martinez, who's a senior legal services attorney who works with legal services, in CSBA. And then Josh Daniels, who's our chief of policy and governance technology services. He oversees the whole department. Next slide, please. So before we get started with our real poll, our one about who is attending our seminars or webinars, we're going to do just a fun one to make sure we all have the hang of it. So we thought about fall and we thought about fall flavors. So if you could just click on what is your favorite fall flavor. So it could be pumpkin, cinnamon, apple, or the flavors really that I miss summer and I'm wishing more for like summer fruits. So well, let's just wait about 5 seconds and then we'll see what our results are. Okay, let's take a look at the results. And it looks like our top choice was cinnamon, followed by pumpkin, and then apple, and a small percentage that are still missing summer. Okay, thanks so much for doing that. So now we'll go on, next slide, please, to our poll, which we hope will be very informative for us. And it's really has 2 parts to it. And like I said, it will help us make sure that we're orienting our webinars properly because who is attending and the focus is very important for that. So the first question is, have you previously attended one or more update webinars? There could be no, this is my first time, which is the first choice. Yes, I have previously attended one or two, the second choice. Or the third choice, yes, I have previously attended 3 or more. So take a little time to do that one. And then we'll move on to the second part is, what is your role in your district or county office of education? Board member, superintendent or administrator, executive assistant, or other. So we'll just wait a few seconds to make sure everyone's had the chance to complete both questions. Okay, and now we'll take a look at the results. I think it's always nice for the people who have participated in answering to see what the results are. So it looks like for most people attending today, it's their first webinar. Well, welcome, and I hope you find it really interesting and helpful. Second is people who have attended 1 or 2, and then a little bit less is people who have attended 3 or more. And let's see, in terms of roles in the district or county office, seems like the highest percent is executive assistants, followed by superintendents or administrators, and then a smaller amount of board members. But it's still very nice to see all the different groups attending. All right, thank you very much for participating in the poll. As I said, it's very helpful to us, and let's move on to the next slide. So at this point, Erin, who I introduced at the beginning, is going to talk a little bit about new Gamut Policy Plus upgrades. So Erin, please take it away.
Great. Thank you, everybody. We're really excited to convey some of the new upgrades that we have released as new features in Gamut Policy Plus. So those of you who have your own Gamut site with a policies module in it are going to be able to see that there are new functions available for you. So to highlight those, I'd like to see the next slide, please. One, we have been asked that it become available to you to choose where you land after you have submitted edited policy language and added your adoption date to it. So now you can select whether you save and go to the work in progress page, you save and go to the policy listing, or you save and close. And this is when you are editing policy language that already existed in your manual. Next slide, please. Now, in the case that you are adding a policy for the first time as new policy language, it's captured as submit and go to work in progress, or submit and go to your policy listing. And that way you'll go to the page that you have selected. Next slide, please. This one's a big one. We're really excited to let you know that you can now unrescind a document. So if you have taken the step to rescind a document from your manual, whether it's a policy, regulation, exhibit, or bylaw, and you have chosen to, in essence, delete it, you can get that language back without having to do any manual work on the front end. So we have added a button here with the arrow pointing to it that will just put it back into adopted status with the dates that were previously applied to it. We're really excited for this new feature. Next slide, please. And so we'll be capturing new features in Gamut Policy Plus. Additionally, we've had a rollout in the Gamut Meetings module, and we're going to be covering those in our standing drop-in sessions that we have every week on Wednesdays at 2 p.m. So we invite you to join us if you'd ever like to. We'll be talking about the features, but the drop-in sessions are also an opportunity for you to come and ask questions of any type in regards to Gamut. And then additionally, we have our Gamut Fall webinar series. We'll be moving into our second session, which will be a deep dive on mastering exhibits in Gamut. So if you're interested in that, please join us on Tuesday, October 8th at 2 p.m. for that. Next slide, please. Now, if you find that you are in a situation where you've got policies that need attention and the number is getting larger by the release, we have a couple of options available to you that can be really helpful. One is the policy manual review, and that's an audit that lets you know which policies you may need to update. And CSBA's policy team compares the last revised date of your district's policies with those in your sample manual. And then we just provide that information to you in a report so that you're able to go through and take a look at the ones that need updating. If you find that there are more policies or you want a more thorough look at the manual as a whole, we have the policy development workshop available to you, which allows you to update your entire manual in one fell swoop. So CSBA policy consultants will then come and work side by side with you to assist you in developing your policy manual and make sure that it is tailored to the needs of your district or county office of education. If you're interested in those, you can reach out to us and policy@csba.org, and we'll get you your options for that. Next slide, please. And in Gamut, Gamut Policy Plus and Gamut Meetings, separate modules, but they work together very well. So if you have one or the other and you're interested in seeing what the connectivity between the two modules looks like, and whether that connected functionality would be something that helps streamline your process, we invite you to take a look. You can make sure that everything's available to you in one site. You streamline, like I mentioned, by connecting your process with the policies and the board meeting management. You can keep all of your users together in one site, and that way you can keep track of contributors that are contributing to both processes in both modules. And then you can search across both modules and all the content therein, which makes it really easy. And then because it's an online software, you can remotely access it from anywhere safely and securely. Next slide, please. Thank you for your time.
Thanks so much, Erin. And now I'm going to introduce again Maryela from Legal Services, who's just going to give about the services that CSBA provides to districts and county offices of education.
Thank you, Barbara. As Barbara mentioned at the outset and just now, Maryela Martinez, thank you all for joining us today. I'm a senior legal services attorney with CSBA's Legal Services Department, and I want to tell you a little bit about what it is that we do. So Legal Services, as some of you may know, is a subscription-based program. And in a nutshell, it's designed to provide CSBA members with cost-effective legal advice and resources. So more specifically, as a legal services subscriber, your district or county office has access to CSBA attorneys, and we can assist with just about every aspect of education law that you can think of. Some of these are on the slide here. They include independent investigations, special education, Brown Act compliance, et cetera, et cetera. Really, it runs the gamut. So in addition to access to CSBA attorneys as a legal services subscriber, your district or county office would also have unlimited access to a resource library, which is a repository of CBAs, MOUs, salary schedules, and legal resources that are specific to education law. So really a great tool for labor negotiations, general education law information, and research in general with respect to education law. The next slide, please. Okay. So as I already mentioned, our services are very affordable. The subscription fee is only 10% of a district's or county office's annual CSBA membership dues for any given fiscal year. And in addition to that, all new legal services subscribers receive the first 3 hours of attorney time free of charge. And in addition to that, districts and county offices that are Gamut Policy Plus subscribers also receive 2 free hours of policy-related legal work when they sign up for legal services. So that's potentially $1,000 of legal work free of charge, as our attorney time is billed at just $200 an hour. So there are other perks that our subscribers receive. I'm not going to get into them in the interest of time, but please do reach out if you have any questions, and we'd be happy to answer them. So that's it for me now. Thank you.
Thanks so much, Maryela. Okay, so now we'll get a little bit more into our presentation. Let's look at sample policies and the basics of sample policies. So next slide, please. So just some general things to know, kind of some definitions. So what are board policies? They're the way that the governing board legislates, and they articulate the policy direction of the district or the county office of education. And as you probably all know, this is really the area that's in the purview of the board. It's clearly the board's responsibility and obligation, and a very important one, to develop board policies. Next, we have administrative regulations, which typically superintendents implement. It's an implementation really for the policy and provides necessary details while staying within confines of the policy itself. And when I said typically, for county offices, since the dynamic between the board and the county superintendent is a little bit different, sometimes these documents relate a little differently to each other, and sometimes we have a specific superintendent policy. So it can be a little different for county offices of education. We also have exhibits, which tend to provide forms, notices, and other implementation tools that, again, are consistent with and go along with a board policy and or a regulation. And then there are board bylaws, which are specific policies that provide the rules and procedures for the governing board itself. And just to keep in mind during this webinar, as well as just, you know, in your dealings with CSBA, as well as probably even just with your board itself, is that policies is kind of used as an inclusive term for all four of these documents, for policies, BPs, ARs, exhibits, and board bylaws. So just remember, when we talk about policy in the general sense, we might be referring to all of them or one of them. So, okay, next slide, please. Just a little bit to know about how our manual is set up if you're not that familiar with it. So we have a numbering system, goes from 0000 all the way through 9,000. We do have a gap for 8,000s, nothing there as a placeholder. And as you can see, each number is by content, whether it's philosophy and the zeros, community relations, the ones, we have students in the 5,000s, instruction 6,000s, and you can see for yourself where everything lays out. The most complicated tends to be the 4,000s, the personnel, only because we have different levels of policies and documents for this group. So if it's a 40 and then numbers that follow, it applies to all classified, certificated, and supervisorial or managerial staff. Then we have separate policies for certificated staff, which would be the 4100 series, just for classified staff, which would be 4200 series, and then supervisorial or managerial, which is the 4300 series. To complicate things just a little bit more, sometimes a particular policy is applicable exactly the same to two of these categories. So we might have a policy that's applicable to certificated and supervisorial staff, and in that case, we call it double coded, or it could be applicable to classified and certificated staff, again, double coded. If it's applicable to all three and the language itself is the same for all three, we call that triple coded. So not to get too caught up in that, but if you are wondering why why a certain policy is listed with 3 numbers, you'll understand a little bit more why that's done. In total, we have over about 800 sample policy documents in our manual. There's a little bit less code numbers. So we have about 550 code numbers. And the reason for this is what was explained, that in one code number, we could very easily and often do have a policy and an administrative regulation. Sometimes we have also an exhibit for there. So in other words, one code number can sometimes have 2 or 3 different documents. Again, most have a board policy. Some, if it's a very, very more technical how-to type of a document, sometimes just an AR. All right, next slide, please. And just to wrap up with our general information, keep in mind that the policies are samples. So all of them, the BPs, the ARs, the exhibits, and the board bylaws, and they should serve as a starting point for your district or county office of education. And we're hoping and expecting, and it's really important to review each policy, but that comes with policy updates, and within the confines of the law, customize them to the needs and the context of your district or county office of education. And like I was saying before, this really is a great time to add each district or county office has its own personality, its own goals that are very important to them, and just its own unique characteristics. And through policy is a way to have that shine, to shine what you're really proud of, to shine what you feel is unique and important, and to also just shine what is required by law. So that's always important. But that brings up a next point, is that the policies have gone through legal review, but always remember they do not constitute legal advice, and they may become quickly out of date. We try very, very hard to keep them all up to date. But as you can see, with 550 plus policies and over 800 documents, we're not always exactly current with each one. We do have dates at the top of each, and you will have dates at the top of each, so you do know when it was last updated. And like I said, we do try to keep them current, but please always be sure that the legal aspect is what your legal advice, whether it's CSBA, District and County Office of Education Legal Services, or your own district counsel, you know, that it's thoroughly looked at and made sure compliant with current legal requirements. Just one last thing, notes are embedded to provide context and additional guidance. Some of you might never have seen the notes. I know I never did as a board member, and learned later about the notes, but the notes are explanatory information and explains more what is in the text or content of the body language itself, of the policy language itself. And they can provide a lot of good context, but also please to remember that they should not be included in the adopted version of the policy. It should just be the policy language of itself without the notes. All right, next slide, please. So we are going to now get into the Title IX Special Policy Update Packet, which I will be presenting on. This came out at the end of July 2024. Next slide, please. So let's first do a little bit of a background about what is a special packet. So as you all know, we release our packets quarterly, our regular packets in March, June, September, and December. And so a special packet is a packet that's released outside of these normal quarterly updates. And they're usually based on law that have an operative date that doesn't fit within the time frame that we work for. And usually not enough information gained to put it in the prior regular update or the one that's coming up. Well, we don't usually have enough information to get into the prior one, and it's usually required to be implemented or operative before the next regular update. So that's when we put out what we call a special packet. It's very, very geared just to the particular instance or law that requires a special packet. So this one is about Title IX. I don't know if you recall, in the fall, last fall in October, we had an instructional materials packet based on AB 1078. And then I don't know if many of you remember, but we also had a COVID packet, which was not based on law. It was actually because there was very little guidance or law out. And we tried to accumulate all the materials we could for guidance for school districts when everyone was still in that very uncertain stage of COVID of what do we do. So that one was put out as a special packet, but not based on law, actually. And luckily, that seems to be behind us now. So let's start with Title IX. So what is Title IX? It's law and regulations, which we'll see below, that are intended to provide protection from discrimination based on sex in education programs and activities that receive federal financial assistance. So that would be district and county offices of education. As you can see here, there are code sections 20 USC 1681 to 1688, and then the regulations, which are in 34 CFR 106.1 to 106.82. And these are the regulations that have recently been revised and the bulk of what we will be talking about today in regard to Title IX. And why, again, we'll be a little more specific now, why we needed to put the Title IX packet as a special packet. So the federal government issued the revised regulations on April 29th, making it hard for it to fit into our, let me go backwards, into our June packet, a little too soon. And then the regulations did become effective August 1st, 2024. So we needed to have them out before September. And of course, we wanted them out before the start of school for districts and county offices. Okay, next slide, please. Okay, so we're going to look just a little bit. I'm just showing you a quick list here of which of the policies were actually revised with the special packet. And again, very geared toward Title IX. It is basically our non-discrimination policy. We're going to go general and get more specific, but you can see our general non-discrimination policies, complaint procedures. We've got lactation accommodations as well as married, pregnant, and parenting students. Some very specific things in those regards in these new or revised Title IX regs. And then also we go into more detail about complaint procedures and sex discrimination and sex-based harassment. Okay, next slide, please. Okay, so there's some general changes that were put forth with the revised regs, which really impact in one way or another all the sample policies. We have almost in there. So some actual language is in there and some are just impacted by the language. But so these are very important for just general concepts that are generally applicable. That the Title IX regs clarified what discrimination on the basis of sex includes. And it includes sex stereotypes, sex characteristics, gender identity, sexual orientation, pregnancy, childbirth, termination of pregnancy or lactation, which also includes related medical conditions of recovery, and parental, marital, and family status. And this had always kind of been a question of whether it was included or not in California, since we have state law that addresses a lot of this. We were already working in this direction. A lot of it was already being done. The other thing that was changed is instead of the term, the more traditional term or historic term of sexual harassment is now sex-based harassment, which also signifies that all of these characteristics, which are being clarified as being included in sex for purposes of sex discrimination and sex-based harassment, is included in sex-based harassment. So so in other words, it's clarified and generalized. Okay. And the other change, which was very big, is that it requires grievance procedures for sex discrimination and sex-based harassment allegations for conduct that occurs or occurred on or after August 1st, 2024. And the important thing here that really got expanded is that previously the Title IX complaint procedures were required of sex or sexual harassment complaints that met the definition of Title IX sexual harassment. Now, the Title IX complaint procedures are required for all sex discrimination and all sex-based harassment allegations. Again, it is, though, for conduct that occurs or occurred after August 2024. So what do we do prior to August 1st, 2024? We use policies in place at the time the alleged conduct occurred, and of course, in accordance with the statutes and regulations that were also applicable at that time. All right, next slide, please. So we're going to get a little bit more specific here, and we're going to talk about our general non-discrimination policies, which are 0410, which applies basically district-wide. We have BPAR 4030, which is geared more towards employees. And we have BPAR 5145.3, really geared for students. So what was included in these, we're going to kind of take them together. We did provide that the compliance officer for non-discrimination and for UCP, for Uniform Complaint Procedures, be the same employee as the Title IX coordinator. And why is this important? The reason why is it's important to have one person at the helm to make sure that the complaints or the allegations are going to the correct, basically a roadmap and going the right way, whether they need to follow UCP, whether they need to follow Title IX. And the real crux here, why it's very, very important, is that a lot of times we have non-discrimination complaints that come to us that cover different types of discrimination. So it could be sexual discrimination, sex discrimination. It could also be based on ethnicity or race or religion. So it's very important that sometimes these complaints have to get bifurcated, and it's very important that there's one knowledgeable person who knows and it coordinates where each allegation and complaint should go. So to these documents, we also added the Title IX Notice of Non-Discrimination, which is very specific content-wise and has specific publishing requirements. And we added this to the list of measures to prevent discrimination, which still exist within our non-discrimination policies. We did a little bit of reorganization of our policies, but we did include all measures to prevent discrimination in these general non-discrimination policies. We included the reference to Title IX employee training requirements, which we'll talk about a little bit more as we get even a little more specific into Title IX. And another organizational thing is that we moved material related to sex discrimination and issues unique to intersex, non-binary, transgender, and gender nonconforming students to our policies on sex discrimination and sex-based harassment, really the student version of that one. And the reason why is the revised Title IX regs, along with my explanation of how the complaints for sex discrimination and sex-based harassment need to follow the Title IX regs. The Title IX regs in general have kind of linked to these two. So we thought it was important to kind of continue with that link in our policy materials. And we'll talk about a little bit more about reorganization as we get to the sex discrimination and sex-based harassment policies which follow. Okay, so next slide, please. So the policies impacted here are for 119.11, and you'll see how it's triple coded here, which applies to employees, and 5145.7 for students. And like I just tried to explain, and this might make it a little clearer, we have changed the title. So the title was previously sexual harassment. That was the title of our policy, and of course accompanying AR. And now we have changed it to be sex discrimination and sex-based harassment. And this reflects the expanded focus and our linkage of the two concepts. So these policies and regulations were updated. We added a definition of sex discrimination and sex-based harassment. We used to have the definition of sexual harassment in our Title IX complaint procedures policies, but we thought it was better and more appropriate now that we're linking these to have them here. Just to know there is state and federal definitions for these two. And another thing important to know is Title IX has a very specific definition for sex-based harassment, which includes quid pro quo harassment. It also includes hostile environment harassment, and then some very specific types of harassment that are listed out. But it's important to keep that in mind when we think of, especially if we're the one trying to figure out about the allegations of sex discrimination and sex-based harassment. Okay, we also updated it to indicate that districts and county offices are prohibited from excluding students from participating in, denying benefits of, or otherwise subjecting students to discrimination on the basis of sex in any education program or activity. We also wanted to identify something that was clearly in the Title IX regs as revised, that we're prohibited from subjecting students to more than de minimis harm in limited circumstances where different treatment or separation on the basis of sex is allowed. This is a very, very specific and very unusual time when it is allowed. But even in this time, we're prevented we may not prevent students from participating in education programs or activities consistent with a student's gender identity, which would subject the student to more than de minimis harm. So in other words, this is a conclusion that preventing students from participating in an education program or activity consistent with a student's gender identity is prohibited. I'm not sure if with all that language, if it came out, but that's the general basis, is we cannot do that. Okay, next slide, please. Okay, so a few more things to highlight here in our sex discrimination and sex-based harassment policies. We further updated them to require specified actions that are required to prevent sex discrimination and sex-based harassment, and to also require training for employees. And just to know, so the training for employees has been expanded a bit. All employees need to receive training, as well as the Title IX coordinator, as well as the employees who are responsible for implementing the Title IX grievance procedures, as well as supportive measures, which we'll talk about in a little bit. And then there's also training required for anybody who coordinates or kind of facilitates the informal training, the informal resolution process, which is only very specific times can that be used, an informal resolution process. Okay, so the other things we've added that district employees with knowledge of conduct that reasonably may constitute sex discrimination or sex-based harassment are required to notify the Title IX coordinator so that the Title IX coordinator can then do what they need to do. One of which is our next bullet, which is to coordinate and offer supportive measures. So what are supportive measures? They are measures that they're kind of interim measures that can be put in place to make sure that the complainant who is alleging the wrongdoing is safe, as well as that there's safety within the educational environment. They also do need to be offered to the respondent once a formal grievance procedure has been started or an informal process has been started. And just to know, very important too, to know that they cannot be used for punitive measures. They're really meant as more protective or supportive measure. Just to also go over now a few more location things of where you will find things in different policies. Our record retention requirements, which are very specific as revised by the Title IX regs, are in our complaint procedures documents, which we will get to in a little bit. We do include material, as I said before, related to sex discrimination. They've been moved from our general non-discrimination policies. And we've removed material related to the posting and publishing requirements, which are now back in our general non-discrimination policies about really under the area of preventative measures. Okay, next slide, please. So a little bit about pregnancy, lactation, and family status. So included in both the employee and the student version, so the employee is 4033 and the student is 5146, is the clarification that protected status, when I say protected status under Title IX, includes pregnancy, termination of pregnancy, childbirth, lactation, and parental, marital, and family status. So this is very important because this ensures that these categories are within the realm of protection from Title IX. So in the student version, we also added, we didn't need to change much. Let me go back in the employee version, because like I said earlier, California already has a lot of protections in place by state law related to this. The student version required a little bit more updating. So let's go over that. We do explain employees' responsibility when they're informed by a student or a person who has a legal right to act on a student's behalf of a student's pregnancy or related conditions to notify the Title IX coordinator. And the notification in all these regards is so important to the Title IX coordinator because that's what gets everything in motion, sets in motion to protect the student and to make sure that the allegations and complaint are handled properly for both the importance of due process for the complainant as well as the respondent. So we also delineate the Title IX coordinator's responsibilities when notified of a pregnancy or the related conditions. One of which is to prohibit requiring a student who is pregnant or has related conditions to provide certification that the student is physically able to participate in a class, program, or extracurricular activity. Always important to remember. And okay, so we have some specific examples about what kind of accommodations to give a student who is pregnant or parenting. But we do have some specific, but know that in the Title IX revised regs, there's a list of accommodations that can be included. It's not a comprehensive list, but it's a very good and thorough list. If we had more time, I would read it to you. It's that good. But at a minimum here, to take reasonable time to breastfeed, express breast milk, and access lactation space, and also to take a voluntary leave of absence. And so the time period for this voluntary leave is at least what is medically necessary. And then the student should be reinstated to the academic status and as practicable the extracurricular status as when the leave began. If a district has a leave policy in place for students, it could be longer, but not shorter than this. And of course, the student would need to be eligible for that. Okay, next slide, please. Okay, we're going to go a little bit into our complaint procedures policies, which are, well, the ones that cover Title IX complaint procedures are for 119.12, for 219.12, and for 319.12 for employees. And for students, it's 5145.71. And then we're also going to talk a little about UCP as the way that these complaint procedures relate. So just to know, complaint procedures were substantially modified by the revised regulations, pretty much in all aspects. And if you would look to our materials and compare them to what they were before, you would see extensive changes having to do with dismissal of complaints and including appeal of dismissals. And there's very, very specific criteria now for dismissals of complaints, for the informal resolution process, for notice of allegations, investigation procedures. The investigation procedures mostly dealing with evidence type criteria, with the written decision, appeals, timeline extensions, and for remedies, disciplinary action, and record keeping. So just to know, I'm going to point out we're running a little short on time, but the definition of complaint has been expanded to include oral and written requests or something objectively understood by the Title IX coordinator as a request to investigate or make a determination. So just know that what used to be a very formal request is not needed to be formal, and Title IX coordinators and employees need to be very careful to watch out for an oral or written request that really is a complaint. There's an expansion of who can bring a complaint, which includes former students. And there are very specific times when a Title IX coordinator is required to initiate complaints, even when a complainant, or I should say complainant, the person who is perceived to have had the allegations against them, or if there's a problem with fair treatment within a district education program or activity. And there's some very specific criteria for the Title IX coordinators to follow to determine when and if they should be initiating a complaint. Okay, next slide, please. Okay, so just a little bit about some specific changes. So we updated our policies to require the application of Title IX grievance procedures to allegations of sex discrimination or sex-based harassment, which is what's required for conduct which occurs on or after August 1st, 2024. But it's not clear in these regulations about what happens with sex discrimination complaints that fall within the uniform complaint procedures, or for employees for established procedures in their 4040 documents. So this does bring up the question about UCP. So our sample policies, after much discussion and much thought and research, is that we have required the use of Title IX complaint procedures and not the uniform complaint procedures for sex discrimination and sex-based harassment complaints. We do include a note in our materials to reflect this uncertainty and the strong recommendation to seek advice from legal counsel to make sure that your legal counsel agrees with this conclusion, or if your legal counsel feels that you should be dealing with this interplay between UCP and the Title IX grievance procedures in a different way. Most important is to be sure of what your district or county office of education adopts, to know what's in place and to make sure that you have legal guidance regarding that. Okay, next slide, please. Just want to really, really quickly, not even going to run through, but just point out that our materials in the special packet did include some other state and federal laws which were applicable to these policies, which we updated at the time. The most notable is AB 1955, which just going to go over the very first part that clarifies that a district or county office education, including a board member, may not require an employee or contractor to disclose information related to a student's sexual orientation, gender identity, or gender expression to any other person, or enact or enforce any policy, rule, or administrative regulation that would require the same unless otherwise required by state or federal law. It goes on then to prohibiting retaliation or adverse action against employees, and also some training or professional development that is required. Okay, next slide, please. These next two slides, which I'm not going to go into, just cover some other areas of state law. Next slide, please, which impact the policies that we updated in the special packet. And then next slide will show our just some federal laws also that impacted these policies that we updated. Okay, next slide. I'm going to hand it over to Maryela just for a quick look at the application of Title IX.
Thank you, Barbara. I'll try to keep it quick. It is really important, so I want to give you a good overview of what has been happening with respect to the new regulations in the court. So, as it states on the slide here, I want to wrap up the discussion of Title IX by addressing whether the new regulations apply to districts and COEs in California, and also giving an update on pending litigation that affects the status of the new regulations. So first of all, the easy question, do they apply to the districts and county offices in California? And the answer is yes, they do apply if these districts and county offices receive federal funding. Second, and more importantly, let's talk about how the new regulations are faring in courts, and that's including the U.S. Supreme Court. Much more complicated discussion. There were multiple immediate challenges at the statewide level as soon as the regulations were announced, not here in California, but in other states. And I'd like to briefly talk about what is arguably the most important of these cases because of its far reach, which I will talk about in just a second. But the case is Kansas v. the United States Department of Education. And this case challenged the entirety of the new regulations, but targeted three main provisions dealing with LGBTQ plus protections. We don't need to get into the specific details of these challenges, especially in the interest of time, because the details ultimately don't matter all that much. They don't matter all that much, these details, but what happened with respect to these protections at the court level are important. So we need to focus on what courts like the court in the Kansas case have issued preliminary injunctions. And these preliminary injunctions prevent the U.S. Department of Education from enforcing the LGBTQ plus protections contained in the new regulations. So these injunctions apply to 26 states. California is not included in these 26. So why are we concerned? Why are we concerned about these injunctions if California is not on the list? And that's because the Kansas case took things a step beyond these 26 states. In the Kansas case, there were three private groups: Moms for Liberty, Young America's Foundation, and Female Athletes United, that joined the litigation. And as a result, the injunction also prohibits enforcement of the new regulations at any school. It's any school, not a district or COE, at any school across the nation attended by members of those groups. So as you can imagine, this opens up a can of worms, because the injunction then extends to schools in the 24 states not covered by the statewide injunctions. And this includes approximately 250 schools in California as of the last time I checked. So just to emphasize, the injunction prohibits the U.S. Department of Education from enforcing the new regulations. The injunction does not prevent districts and COEs from adopting policies that incorporate the new regulations. Of course, as you can imagine, again, this creates a patchwork quilt as far as the regulations are concerned. And in California, for instance, some schools will operate under the 2024 regulations and have those enforced, but others cannot have the U.S. Department of Education enforce them, and will typically stick with the status quo, which is the 2020 regulations. I mentioned that there were about 250 or so schools on the list where members of those three groups attend throughout the state of California, but that list could grow. The plaintiffs in the Kansas case have already supplemented their list twice, again, as of the time I last checked, which was just a couple of days ago. So that said, districts and COEs need to be prepared to switch over to the 2024 regulations because injunctions are temporary, of course, and can be changed fairly quickly. I want to note also that the Biden administration sought enforcement of the provisions that are not the subject of the injunction. So if you recall, the subject of the injunctions were limited. And so this request by the Biden administration was denied by the US Supreme Court last month. The result being that the injunctions apply to the 2024 regulations in their entirety. So I want to close with a very important reminder, and Barbara talked about this, but it bears repeating, and that is that California law already encompasses basically all of the protections contained in the new regulations. The California Education Code protects against discrimination on the basis of gender identity, gender expression, or sexual orientation. So regardless of what happens at the federal level, with respect to the new Title IX regulations, California districts and COEs, all California districts and COEs have to adhere to the state law as well. Okay, that'll do it for me with respect to the new Title IX regulations.
Thank you, Maryela. Okay, so next we will take on a few questions related to Title IX. One was answered by Maryela, so thank you for the question, and thank you, Maryela, for explaining. And I'm hoping I might get a little assistance from my team for some of these questions, especially the ones that have a little bit more of a legal basis to it. So we'll just try to run through them as best we can. First question, if a district is a TK through 8, does it need to have policies for married and pregnant students? And what about policies generally that in practice only apply to high school students? Well, for specific, in terms of TK through 8, you definitely would still need to have the lactation accommodation for employees. So that one would need to be kept. I actually would look for guidance from my team about the married and pregnant students. And I think it relates, my answer so far though, is it relates to the general question about if it only, generally about policies that only apply to high school students. We have a mandate list. Certain policies are mandated to actually have policy in place by either state or federal law or regulations. So it's very important to look at that mandate list. We can provide it to you. So that can help explain generally if you would need to have a policy that perhaps just applies to high school students. But in terms of the married and pregnant students, I have never heard of a caveat that you do not need it, but Maryela, you might have more legal guidance on that.
I don't have anything to add with respect to that, Barbara, but I will be happy to answer other legal questions that may come up.
Thank you. Yeah, I mean, to be safe, I would suggest to have that policy in place. You could always, not trying to be promotional here, but you could contact the CSBA Legal Services to give you an answer, or I'm sure your own legal department could answer it too. I always err on the side of safety, so I would say good to adopt it. Does Title IX cover allegations of sexual assault? There's 2 about sexual assault, so let's try to handle them together. When there is a sexual assault allegation and law enforcement is involved, is the school required to initiate its own investigation under Title IX? Again, my suggestion would be yes, only because there could be a complaint that alleges sexual harassment or is alleging sexual assault, which really amounts maybe to sexual harassment, or I should really say sex-based harassment, which in that case, you would need to follow the Title IX procedures. So my recommendation would be to follow the procedures and then also follow the route for a sexual assault claim. I don't know if my peers have anything to add to that. If not, we'll move on to the next.
I agree with everything you said, Barbara.
Okay. And then we'll move on. Thank you, Maryela. To do we need to add names of the Title IX coordinator to any of these policies? Yes. And there's blanks in the ones highlighted in yellow to the ones that it does need to be added to. I don't want to make a mistake, but I believe it's in our general non-discrimination policies as well in our sex discrimination and sex-based harassment policies, but please check, you'll see them. It'll be obvious yellow highlighting. You don't need to wait till litigation is resolved, as Maryela explained, and to update your policies. Very important to update them now, and that's why we did our special packet to get them out timely. Okay, any more questions about this? we will handle
But
it.
I think just to clarify, Barbara, on that last question,
Okay,
if a district believes that or county believes that their policies are up to date under California law,
okay,
because you mentioned earlier that, or Maryela, you mentioned that basically the protections under Title IX are already existing in California law. So if you believe that your policies are up to date under California law, should you put a pause on updating your policies in light of Title IX until the regulation of litigation is resolved? Or should you still update your policies in light of Title IX, notwithstanding the fact that the litigation is still ongoing? So I don't know, Maryela, if you want to take a crack at that one.
Sure. Thank you, Josh. Yes, in light of the ongoing litigation, what you need to remember is that not all districts are covered. We're talking about individual schools that are covered, which of course creates an additional layer of complexity. But it's my opinion that yes, even if the California law is incorporated into the policies as they exist now, the new injunctions do not affect the ability of the districts or county offices to adopt the new regulations or to incorporate them into the board policies. It just prohibits the U.S. Department of Education from enforcing them.
okay, thank you, Maryela. And we're going to stop, like I said, we're going to stop now with the Title IX questions. We hope to have time at the end to answer and address more of them, or again, you'll be provided information to ask your questions in writing directly to us. So, or we could do it through the information we received from this webinar. So we are going to move next on to some discussion about technology as part of our September policy update packet. And in order to do this, I'm going to introduce Dustin and Josh again and Maryela, who will be speaking to technology. Before we get there, let's just look at this. Is just shows an overview of our packet, our September packet, as well as the asterisks show the policies that we have unique versions for county offices of education. Yeah, and we produced 3 specifically for county offices this time. Okay, in addition to some others. Okay, so on to technology with Dustin, Josh, and Maryela.
Thank you, Barbara. We're going to review policies updated related to technology. They're listed here. They particularly focus on use agreements and AI, and then some updates related to use of social media. Next slide, please. The first one I wanted to highlight was we updated the district versions of BP and Exhibit 4040. And we also created county-specific versions of 4040. These were updated primarily to outline the appropriate use of AI by employees. In the BP, we wanted to further clarify the role of technology for in the governing board's philosophical statement, and it was revised to include the recognition that technological resources enhance employee performance, enrich curriculum, and enhance student learning. We wanted to incorporate AI and software as a service into agreements regarding prohibitions against accessing, posting, or engaging with harmful material. We wanted to inform all the parties of their responsibilities regarding data protection and cybersecurity, and to notify staff that they should have no expectation of privacy and confidentiality when using district or COE technology. Finally, these agreements provide students and staff with possible consequences of misuse of technology or the misuse of AI. Finally, next, this policy was updated to add material to ensure staff and students understand the shared responsibilities related to cybersecurity, data privacy, and digital media awareness. Finally, one last inclusion was a Labor Code 1139, which provides employees may access their mobile or other communication device if there is a need to seek emergency assistance, assess the safety of a situation, or communicate with a person to confirm their safety. Similar additions were incorporated into the exhibit, which offers districts and county offices a sample technology use agreement that they could use and modify to share with employees. This exhibit also adds that districts and COEs may not prevent or restrict access to mobile or communication devices in those emergency situations. Next slide, please. We also updated the district versions of the student use of technology 6163.4 and created county-specific versions of this. Similar changes were made to incorporate AI and software as a service into agreements regarding the use of technology. These revisions also expanded the governing board's philosophical statement to include the effective use of technology, discussion on digital citizenship, and access to the latest digital tools. The student use of technology will be in accordance with district policies on academic honesty, data privacy, non-discrimination, and copyright. Policy was also updated to add material related to the regular review of current guidance regarding cybersecurity, data privacy, and digital media awareness. Similar additions were made to the exhibit, which is a sample student use agreement that districts can use and modify as a template for agreements with students and families. This exhibit was updated to add that students are prohibited from using district technology to create material that is discriminatory, libelous, defamatory, obscene, or disruptive. They are prohibited from sharing confidential information or personally identifiable information with OpenAI systems. And it also lists other prohibitions. In addition, the exhibits were updated to include internet searches, browsing history, and the use of artificial intelligence in the list of district technology that districts may monitor. And these agreements serve as important tools to help districts and county offices ensure that staff and students understand their responsibilities related to the appropriate use of technology, in particular, the appropriate use of AI and the potential consequences of misuse. I will now turn it over to Josh, and he will talk a little more about social media revisions.
I'm actually going
first,
to take
yeah,
this.
go ahead, Maryela.
Yes.
Go ahead.
All
Sorry.
righty. Thank you, Dustin. So I would like to discuss the U.S. Supreme Court decision in O'Connor Ratcliffe v. Garnier, and that is from March of this year. And the U.S. Supreme Court considered in that case how to apply First Amendment protections to public official social media accounts, and held that a public official who limits or prevents critics from speaking, such as by blocking them on social media or deleting their posts, violates the First Amendment only if the official, one, has been granted the power to speak on behalf of the governmental agency, and two, claims to be actually exercising that power. So the decision reinforces First Amendment rights of school board members because it provides for a new and more restrictive test. This test is more restrictive than what existed prior to this decision, and it applies in order to determine when public officials can be held liable for First Amendment violations related to management of their social media. And so the decision in this case is a resounding victory for school board members. Okay, so let's take a step back to put this in context and determine what it all means. As a little background, and some of you may know this, but federal appellate courts are divided into circuits. In California, for instance, we fall under the Ninth Circuit. And when different circuits reach conflicting opinions, it's called a circuit split. And the U.S. Supreme Court is more likely to hear the cases. And that's what happened here. The slide mentions Linkey v. Freed. O'Connor Ratcliffe comes out of the Ninth Circuit. Linkey comes out of the Sixth Circuit. And so we've got a circuit split between Ninth and Sixth Circuits. And in both instances, the constituents claimed that public officials violated the First Amendment by blocking individuals from their personal social media accounts following a repetitive string of negative comments. So in the interest of time, I'm not going to go much more deeply into the differences between these two cases, but I do want to mention that when it came before the Supreme Court and the Supreme Court reached the conclusion of the two-part test that I mentioned, it was in the Linkey case. Again, it mentioned that Freed, who was the plaintiff in that case, did not relinquish his First Amendment rights, or rather the defendant in that case, I'm sorry, did not relinquish his First Amendment rights when he became a city manager, and that the presence of state authority must be real, not just a mirage. Then the Supreme Court went on to mention the restrictive test that I already referred to. And instead of issuing a second opinion in O'Connor v. Radcliffe, the Supreme Court returned the case to the Ninth Circuit to rule in light of the test announced in Linkey. So again, that test is a two-part test, and it is much more restrictive, a resounding victory for school board members and other local and other elected officials, and again, a violation of First Amendment. Only if the official has been granted the power to speak on behalf of the governmental entity and claims to be actually exercising that power.
All right, thank you, Maryela. So the holding in Linkey, as Maryela described, is going to be found in all of the other policies that we're going to be discussing. So wanted to just cover that piece first. So there's a BP and an AR for 1114, district-sponsored social media. And it sort of adds in a bunch of language sort of in light of Linkey. It makes some updates to sort of the language, so using account versus say platform or site. There are some other requirements as relates to access for individuals with disabilities. But I would say that the key piece here as you review these policies is that in light of Linkey, it basically restricts. It provides a foundation such that only in limited circumstances is there the official district media account. So it provides board members and district officials and county officials with protection so that any private account you have isn't presumed to be a public account. There are also some language that we clarified as relates to a public forum, making it clear that even if there is a online discussion that relates to district business or county business, it doesn't create an open public forum, which would provide for more First Amendment rights to the people who comment on that public forum. So the notes explain it a little bit further, but it's something to update and pay attention to. Similarly, on the AR, the one thing that the AR includes that the policy BP does not is that it does talk about how you might suspend a user, so someone who keeps commenting on your Facebook site, things like that, when certain conditions are met. Those conditions are not specified in state law, so you can set your own conditions, but it is strongly recommended that you set those conditions so that any suspension could be done objectively and fairly, and sort of apply the rules across the board. And then there are two related board bylaws. One is 9010 about public statements. And this rephrases some of the language in the board bylaw so that it really focuses on individuals speaking for the board, because it is a board bylaw after all, rather than the entire district. It talks about, making sure that when someone is speaking as an individual board member, that you clarify that that is your individual board member role, not on behalf of the entire board or your LEA. And it suggests, it has some language around a disclaimer to the social media site so that it can be clear who you are and are not speaking for. In terms of the other board bylaw, 9012, so this gives a suggestion about how to avoid Brown Act violations. So if you are a superintendent and you are contacting the entire board, the recommendation is to blind copy the entire board, so that if a board member accidentally CCs, replies all, the whole board isn't included. Similarly, if a member of the public, there's like an email address that you send an email to that goes to the entire board, that would not a board member couldn't reply all and then again CC all the board members without realizing it. And just sort of as a reminder that we added this in here, that under the Public Records Act, any district communication, including board member communication, as it relates to district business, is a public record regardless of the device that it is sent on. So if it is a personal email account or if it is a personal cell phone, it is still a document that could be disclosed under a PRA, and we all need to remember that. And then I won't go over these. So there were 3 policies that we updated a year ago in September 2023. Academic honesty, one about homework, and then one about assessment. We have created the unique county versions that go along with those 3. So the content of each is in the slides. They're listed as new in the county packet, but for context, they were created based upon what was done in the district versions. So these are the other 2, and I will turn it back to Barbara for this point.
Yeah, thank you so much, Josh and Dustin and Maryela. We have a couple of questions on the technology policies. One is, are there exceptions included in technology use policies for employees or students who have who use technology for disability access? There's examples, but I think for the interest of time, we'll just give an answer. Dustin, you want to handle that? You want me to?
The short answer is yes. Those are appropriate uses of AI and technology. Our policies were meant to be inclusive and expansive, so we are not trying to restrict the appropriate use of AI, just more the dangerous sides of helping districts find that balance. You want to add any more to that, Barbara?
No, I thank you. But I agree that yes, if it's in a student's IEP, then there are exceptions and important to follow the IEP for the student, or a 504 plan too. Yeah. Second question is there a CSBA legal brief that explains the impact of the First Amendment protections from the linked Freed case? And I'm not sure. I would actually have to research that. Does anybody know offhand on our panel?
I believe there is one, and I will put the link in the discussion box there.
That would be great. Thank you, Maryela. One more question just came in. Is the specific language in 9012 regarding emojis, likes in direct response to a court holding governing California in the Ninth Circuit? Josh, you'd probably be a good one for this.
Yes, actually, that language has to do with state law. So state law clarified when sort of board members commenting on each other's stuff does and does not violate the Brown Act. And it did include that you shouldn't be commenting, liking whatever other board members' Facebook or Instagram posts or whatever, because that could basically constitute your agreement with a particular statement in a public way outside of a noticed meeting. So that it's not so much the Linkey case, but it is state law that includes that.
Okay, thank you. I think now we should move on to our math policies, which will be, so next slide, please. Which will be presented by Dustin.
Thank you, Barbara. I'm ready for the next slide, Josh. We updated 2 math policies, BP 6142.92 and BPAR 6152.1. These revisions focused on incorporating the new California mathematics framework. In particular, this framework offers guidance to help educators design and align classroom teaching with the math learning standards. So the framework is meant to align with the math state content standards. One of the main goals of this framework is of removing barriers to students' math success and ensuring access and opportunity for all students to receive high-level math instruction. and we incorporated this language into 6142.92. In terms of math placement, we wanted to add some of the mathematics framework language related to creating multiple pathways so students are able to access advanced math courses. These pathways encourage districts to diversify their options they offer in order to fit the unique needs of more students and ensure they can reach those advanced math courses. In many ways, this framework sets the vision for the state on high quality math instruction for the coming years. More information about the math framework can be found on CDE's website. Next slide, please. Real quick, if there are any questions, I'll be glad to take them, Barbara, or we can move along.
I think we should just move on right now in the interest of time. And
Okay.
again, if there are questions that come up, we could try to address them at the end, or we can, address them on a one-to-one basis with the person who's asking the question. So let's move to other policies in our September packet that were updated, and Megan will be presenting on this.
Thanks, Barbara. And I understand that we are going a little bit over time, so if people need to hop off, that's fine. And please know that we will send out a recording of the presentation as well as the slide deck. So I'm going to be talking about a few policies that we haven't included so far. Next slide, please. The first I'm going to be focusing on is suspension and expulsion due process. So SB 274 has eliminated the disruption or willful defiance from a reason to suspend a student. This was formerly applicable to students in grades K through 8, but now applies to all students. And for students in grades 6 through 12, this exception is prohibited, or it's going to be until July 1st, 2029. So until July 1st, 2029, there is no more reason or choice to suspend students for disruption or willful defiance. And we'll see in 2029 if the legislature extends that prohibition. But I also wanted to note that teachers can still suspend a student from class. So they still permit in-school suspension for willful defiance. So that's still an option. There's also part of 274, they have prohibited the suspension or expulsion of a student, and that's solely on the basis of if the student is truant, tardy, or otherwise absent. And next slide, please. And we also updated the administrative regulation. And we included AB 1165, and this encourages districts to have a student who has been suspended or for whom other means of corrections have been implemented for an incident of racist, bullying, harassment, or intimidation to engage both the victim and the perpetrator in restorative practice suitable for the needs of the students. To require the perpetrator to engage in a culturally sensitive program that promotes racial justice and equity and combats racism and ignorance, and also to regularly check on the victim to ensure that the victim is not in danger of suffering from any long-lasting mental health issues. Again, AB 1165 encourages districts to implement these in their policies. And then we also added that for the notice to parents and guardians that it shall include the date and time when the student may return to school. Before it was permissive, but it's best practice to include that information when that notice goes out to parents and guardians. So next slide, please. We also updated AR 5144.2, which applies to students and expulsion of students with disabilities. And please note that there is no BP for this. There's only the AR. And I don't know if Maryela wants to join in at some point on this slide, but you're more than welcome to. The main issue that we identified and updated for this AR is that there was some confusion because federal law And Supreme Court case permits districts to suspend students with a disability for not more than 10 days, as long as the removal doesn't constitute a change of placement. However, state law limits the suspension of any student for not more than 5 consecutive days or 20 cumulative days in a school year. There's a few exceptions, of course, then to this general rule, and that's for if the student has been recommended for expulsion, if the student is suspended directly by the board rather than a school administrator, or if the student transfers from schools, then the student can be suspended for more than that kind of general 5-day rule. And so there's a conflict of state law and federal law. And when there is a conflict of laws, we go with the more restrictive law. And in this case, it's state law. So again, we would generally say that students cannot be suspended for more than 5 days. I want to note that this is somewhat confusing. And so if your district is suspending a student and there are questions about this, to please consult with your legal counsel. And so next slide, please. We also updated BP 5147, which is dropout prevention, and note that for this one, there's no AR, just the BP. So for this, SB 153, which was passed this year, permits districts to implement an attendance recovery program, and that is for any student, TK through 12th grade, for them to make up lost instructional time and offset absences, and that's limited for up to 10 days in a school year. It's important to note that student participation is optional, and that these programs can be operated before school, after school, on weekends, during intercession periods, and that districts who choose to implement an attendance recovery program have to offer these programs throughout the school year, including at least once during each term. So if your school's on a trimester, they have to offer them once during each trimester. And then for this policy, we also included information from CDE's adjusted cohort graduation rate 2024-25 federal program monitoring instrument. And that requires districts to have written policies and procedures to maintain required documentation for students who transfer or withdraw from a school, including the exit reasons and documentation to support the exit reasons. And then we also expanded the strategies to support students at risk of dropping out of school. And next slide. We also updated BP and AR 6112, which is related to the school day, and that is reflecting SB 291 and SB 153, which require districts that maintain grades K through 6 to provide at least one recess for 30 minutes on regular instructional days and 15 minutes on early release days. And we also clarified that instructional minute requirements for students in grade 9 through 12 in independent study, and delete some language that are governed by other policies. Next slide, please. We also updated the Williams uniform complaint procedures, and I will probably breeze through these ones a little bit because we were focusing on the other ones, but I wanted to note that they were updated to reflect new laws, talking about stocking school restrooms with menstrual products, and also something that is on the horizon in 2026 about having gender neutral, all gender restrooms beginning in 2026. So we updated the AR and the exhibits for that. So next slide, please. And again, I just wanted to note that these are related to, to deficiencies and facilities deficiencies, and that you can, if you're interested in this, we're going to be sending out the slides so you can read more about those details. So next slide, please. and again, we updated this one to note about restrooms, all gender restrooms, and stocking restrooms with menstrual products. So if there's any questions, I'm happy to try to address those.
Megan, so we do have a couple. One
Okay.
is, can districts make restorative practices mandatory in their AR 5144.1?
Yes, so that's up to the districts. The new law encourages it, but if the district wants to modify their policy to make that a requirement that administrators utilize that, then yes, they can.
Thank you. And there was a second question too, which is, if you are going to move to expulsion, but the next board meeting will be longer than 20 days, does that then require that we put the offender back in school?
I will defer to my other panelists for this. This is not my area of expertise. I do believe that if there's a pending expulsion, it extends the limit, but I would love for somebody else to weigh in on that as well.
Maryela, do you want to take that, or do you want me to take it?
You can go ahead and take it, Josh.
Okay. So there is the ability to extend, but it can't be imposed by the district, and I believe it's 30 days, not 20. And that being said, if you don't have a school board meeting scheduled within 30 days of suspending somebody pending expulsion, you should schedule one, because that is what the rights of students would require under state law.
Okay, thank you. And that should wrap it up for our questions related to Megan's presentation. And now we'll move on quickly to, so next slide, please. We'll do just a quick evaluation of how we did. If you guys could please participate in the poll that we're about to bring up. And the questions are, how would you rate the webinar? Incredible, which is a 5, 4, really helpful, 3, good enough, 2, barely okay, or 1, not worth my time. Again, your participation will help us do a better job for you. Okay, let's give it a few seconds, and then we will, Josh, when you're ready, we can look at the results. Okay, good. Well, most people found it really helpful, so that's very good to know. A few incredibles, good enough, and we didn't get any barely okays or not worth my time, so that's great to know. Let's move on, because important too is to answer your guys' final questions, which if you're still hanging on, we will do right now. So the first is, our district recently adopted ARs 5145.7 and 5145.71 for both sex-based discrimination and Title IX sex discrimination and sex-based harassment. Are these redundant? No, these are not redundant. The 0.71 are the complaint procedures themselves. And the 0.7 is the general sex discrimination and sex-based harassment policy. So no, not redundant, and good that you adopted both. 2, we adopted policies but included positions, not names. Is that acceptable? I'm assuming that's in the Title IX ones for probably the Title IX coordinator. As far as I can see, yes, that should be fine. Very important though to have the contact information in. So, because that is required, and you'll see the blanks in the policy. So definitely make sure the contact information is in there appropriately. I guess even if it's by title, have the contact information there, please. For sex-based harassment involving a student, how does Title IX impact the ability of a school to suspend a student? I'm going to defer to Maryela, but I will tell you that there are some basic tenets now and a lot of due process for the respondent in the Title IX proceedings. So I know the supportive measures cannot be used for disciplinary reasons, so that could not be used to suspend. And my understanding is that before any punitive measures are put in place, it has to be once the Title IX grievance procedures, the complaint has been final and there's a written decision, including an appeal and all that. So I actually don't know how the appeal would play out, but at least a final decision. So my understanding is you cannot suspend a student prior to that. I don't know if any of my peers feel that that should be clarified. Not, I'll move on. So are the Title IX complaint procedures triggered by an allegation of a hostile environment? Should staff be directed to bring these kinds of concerns to the Title IX coordinator or to their site administrator? That is one of the ways. We talked about a definition of sex-based harassment. Hostile environment harassment is one of the ways. Yes, and it's good. It's part of the employee training for staff to be aware, and that should be brought to the attention of the Title IX coordinator. Because remember, it's the protection of the complainant or the person who has allegations, as well as the protection of the district as a whole, to make sure that you're providing a non-discriminatory environment in the education programs and activities. Are AR 5145.71 and 0.7 available to county offices? Yes, we have unique policies for county offices for those two. On recess time, is it supposed to be read as one continuous 30-minute recess, or can it be 2 15-minute? My reading of the law is that on what is called a regular school day, let me make sure I have the term correct. Yes, regular instructional day. The way I read the law is it should be one continuous 30-minute period of time. That's my reading of the law. I don't know if any of my peers have a different reading of it. You can always double check with your legal counsel, but that would be how I read the law. And if there's nothing else to add, I think we will conclude here and just thank you so much for attending. Please feel free to contact us if you have any more questions, and hope to see you next time. Bye-bye.